Hello, everyone, and welcome. I want to thank you for attending this webinar, which is the first presentation in our month-long series, which is dedicated completely to the manufacturing industry. Very happy to have you here for this kickoff event and invite you to join us for the remaining sessions that are scheduled this month. By way of introduction, my name is Tyler Hendry. I now work out of Bond's New York City office, but I spent the majority of my career working in the Syracuse office, so I cannot yet consider myself an official downstater. My legal practice is heavily focused on labor negotiations, arbitrations, and practicing before the National Labor Relations Board, as well as a significant amount of federal and state court litigation involving the topic today, which is sexual harassment. Presenting with me today is Kate Hajar, who is in fact an official downstater. And hello, Kate.
Thanks, Tyler, very much, and thanks everyone for joining us. I'm also in the New York City office of Bond and a downstater, as Tyler said. Maybe our accents will give us away today. But my practice includes counseling on a range of labor and employment matters. I do a large part of employment litigation involving sexual harassment and training for client representatives on workplace investigations, particularly conducting sexual harassment workplace investigations.
Thanks, Kate. So now turning to the topic for today, the last few years have seen a very dramatic shift in attitudes and treatment towards sexual harassment in the workplace. Now, of course, the biggest examples are in the politics and entertainment world, simply because of the nature of media reporting, but nearly all industries have felt this impact. Many big names in a variety of industries have had their careers ended because of misconduct dating back many, many years. Now, while manufacturing has not had quite as highly of a publicized event as these other fields, it does share one very important characteristic with these other fields. That is, in politics and entertainment, there was certain conduct that was often kept quiet or treated just as the way things are, or any other number of other excuses for condoning improper conduct. And there was just this culture of silence and treating complaints as snitching. And this is what created cultures where inappropriate conduct was allowed to continue for decades and never came to light. So the reality of many, and of course not all manufacturing environments, is a culture that has been created over the last 50 years. These jobs remain largely male-dominated, and they are very difficult jobs. And part of what employees would view as blowing off steam and what some employees may consider keeping things light have resulted in an environment where there are a lot of raunchy jokes, making fun of other employees, which is pretty harsh at times, and one industry where sensitivity is not necessarily one of the top priorities. From the supervisory level on down to the employees that are out there on the floor. So I've handled a number of these cases over the years in this industry, and the first response from many supervisors is surprise, because the things being complained of are simply just the way that things have always been over the course of the last 20 or 30 years. And no one had an issue with it before, so why are we talking about it now? Things have always been this way. Why are we talking about it now? And when you bring that supervisor into an EEOC investigation or investigation with the government, and their defense is, well, that's just how things are. Nothing's changed. Nobody had an issue with it before. You essentially get laughed out of the investigation, and you have to settle, or you have to give some sort of significant monetary amount, because the defense of that's just the way things are is not an acceptable defense. So the goal today is to make changes to these cultures before an EEOC charge or a court complaint is filed, and you have to rely on that defense of, well, that's just the way things are. Again, that's what today is about. I know many employers we work with, and I recognize some of the names today, are doing all the right things to make that change from the HR level on down, but changing a culture that has existed for 50 years is not an easy thing to do. This doesn't happen overnight, particularly with employees that have been there those whole 30 or 40 years. It's not an easy change to make. So this presentation will address that difficulty and provide steps on moving toward that change. But first, before we get started, I want to give a little plug for the upcoming webinars for Manufacturing Month. We're covering a very wide variety of topics from GDPR to succession planning for your company, and there are a lot of great speakers that are involved. Also, if you aren't able to make all those presentations, each of the presentations are going to be put up on our website for you to watch and review when you get a chance. All right, so here is our roadmap for today. We're going to start by going over some basic information on harassment in the manufacturing industry, then jump into the legal framework for evaluating these cases, and we'll do this by going through some hypotheticals. Also want to cover some special considerations for those of you in unionized facilities, as of course you have to worry about an additional third party with the union being involved when conducting investigations and making any kinds of policy changes. And finally, hopefully will be useful for you, is we're going to cover best practices for trainings, investigations, deterrence, and how to navigate this increasingly complex area without you or your company becoming one of those publicized cases in the media, which we want to avoid. Also, since this is a relatively small group here, I want everyone to feel free to ask questions throughout this presentation. Type them in. We'll have them and we can review them. And then please participate. There'll be some hypotheticals. We'll ask you to participate if you're still paying attention at that point. And again, because this is a small group, we should have the time and ability to respond to your specific questions you may have. And if we don't get to every question, our contact information will be provided at the end of the presentation. Feel free to reach out with any questions. All right, so here are some of the recent headlines. While the manufacturing cases haven't gotten the biggest headlines, they are getting more frequent, and the Ford case that's mentioned here highlights the very significant difficulties in changing a culture. And it also provides the most well-publicized case thus far in the manufacturing industry. For a little background, there are two giant Ford plants in Chicago. And in the mid-90s, they went through a sexual harassment case before the EEOC that resulted in a $23 million settlement for the employees at issue. However, so that happened in the 90s. Just 2 years ago, in those same exact two plants, another group of female workers filed charges that just resulted in about 6 or 7 months ago, a $10 million settlement. And the following is a direct quote from an article explaining these most recent allegations. And it's quoted, there's a number of women who are in this article. And this is what was said about that environment in the manufacturing facility. Bosses and fellow laborers treated them as property or prey. Men crudely commented on their breasts and buttocks. Graffiti of penises was carved into tables, spray painted onto floors, and scribbled onto walls. They groped women, pressed against them, simulated sex acts, or masturbated in front of them. Supervisors traded better assignments for sex and punished those who refused. That was a quarter century ago. Today, women at those plants say they have been subjected to many of the same abuses. And like those who complained before them, they say they were mocked, dismissed, threatened, and ostracized. One described being called a snitch bitch, while another was accused of raping the company. Many of the men who they say hounded them kept their jobs. This quote, these examples, really what this shows is that even with a massive settlement and a finding of liability back in the 90s, nothing changed for many of these workers at the ground level up until today, and it's still going on likely today, because you can have all of the best policies in place, all of the best mechanisms for reporting, but if you don't know what's actually going on at that ground level and understand what's being kept quiet, what people aren't reporting, you'll never be able to change that culture in a significant way. So, moving on, so this next slide again further highlights the depth of the problem, and I promise we will shortly get into a way to combat this problem rather than just highlighting the depths of it. But here are some just basic numbers on sexual harassment over the last 10 years. These numbers are taken from a 10-year study that was conducted by the EEOC, which is the Equal Employment Opportunity Commission, which, as most of you know, is an agency tasked with investigating claims of sexual, racial, and other forms of harassment. Now, these numbers below that you're looking at on the slide focus exclusively on sexual harassment. Significantly, early studies from the last 2 years indicate that these number of charges filed are on the rise. As you can see, 83% of the sexual harassment charges are filed by women. However, male-on-male sexual harassment cases are on the rise, as well as harassment claims by males against female employees. So it's very important here that when you think about this problem and this issue, you should not only view it in the lens of male-female sexual harassment. That is not the sole way to look at this problem. There can be male-on-male, female-on-female, or female-on-male. All of those are covered by sexual harassment. And for me, I think that the most glaring and frightening statistic on this page is that only 6 to 13% of individuals who feel they may have been the victim of sexual harassment ever lodge a formal complaint. While some of these individuals may file an internal complaint with the company and it stops there, there is a much larger percentage who fear what may come from filing a complaint, and they remain working in an uncomfortable environment or never say a thing and just move on to a new company. Now, the goal for those in attendance here should be to be that company where employees know they are free to file internal complaints without retaliation and know that the complaints will be investigated, and hopefully an employee does not feel that the EEOC is necessary in achieving the help they feel they need. Now, it's not always possible, but we will discuss the steps to take to attempt to get there, and also to ensure that if an EEOC charge is filed, you can show an investigator in writing the reasonable steps you took to attempt to address the behavior in question. So now the study I just mentioned also studied specific industries and highlighted the industries with the highest sexual harassment charges filed. I don't know if anybody on here wants to guess where manufacturing industry falls on this, but we will start with number 1 on the list, and perhaps not surprising is the hospitality industry. Waiters, servers, bartenders, environments where alcohol is involved. Not entirely surprising that sexual harassment is prevalent in this industry. Second on the list is the retail industry. Studies have linked high numbers in the retail industry to the lower wages in that industry. I mean, as those who are more economically vulnerable are less likely to file a complaint because of the fear of losing that job. They are living paycheck to paycheck, so they can't file a complaint and then fear that their job may be gone because they're being retaliated against. Also, a big factor is that HR functions are typically very light in the retail industry as well as in the hospitality industry, so the complaint process is often murky, and many times you could be forced to file a complaint with the same exact person who was allegedly sexually harassing you. And finally, third on this list, as you see, is the manufacturing industry, which was surprising to me that the numbers were so high for the manufacturing industry, that you were up there with the hospitality and retail industries. This is certainly not because there are problems in the industry, but when you look at the statistics on the previous page, 83% of the individuals who file EEOC charges are women. And in the manufacturing industry, still today, women only represent 25% of the workforce. So in comparison to almost every other industry out there, this is an industry that has a very low number of female workers, so I would have assumed that the manufacturing industry could not have been up there with the hospitality and retail industries, just because these other industries are so much closer to 50-50 men and women, or even have more women than men. So what being third on this list does is highlights the significance of the problem in the industry. Even though the number of total women is small, this means they are filing complaints at a much higher rate than any other industry. And with only 6 or 13% of potential victims filing complaints, this means there are a number of individuals at manufacturing workforces that are enduring an uncomfortable and potentially dangerous environment on a daily basis, and they likely feel they have nowhere to turn to make that stop. And this is highlighted further by the fact that 75% of employees in these manufacturing cases also claim they were retaliated against when they tried to make a complaint with their supervisors or with their HR or their managers. So these numbers are somewhat sobering, I would think. But now the focus of the presentation is going to be on what you can do to address it and steps you can take to start addressing and making those cultural changes so that ensure that you don't have that fearful employee who dreads coming into work day in and day out.
So what we're going to do at this point is go through some of the legal basics. And the purpose of that is so that we understand what sexual harassment is in the eyes of the law. And we're going to be looking at federal law and state law that controls in this area. We're going to be looking at these legal frameworks so that we understand as employers what our obligations are, to maintain a harassment and discrimination-free workplace, and what types of behavior, whether it rises to the level of legal sexual harassment or not, employers need to address in order to, as Tyler was talking about in the beginning of this presentation, kickstarting behavioral changes that may be necessary in the workplace. So what are the relevant laws in this area? We'll start by just talking briefly about Title VII. This is Title VII of the Civil Rights Act. This is a federal law applicable to employers, which states that sexual harassment is a form of sex discrimination prohibited in the workplace. It defines sexual harassment as unwelcome sexual advances, requests for sexual favors, verbal or physical conduct of a sexual nature when it affects an individual's performance or creates a hostile or offensive work environment. The EEOC, again, as Tyler mentioned, is the federal agency, as I'm sure all of you are well aware, that enforces the federal laws in this area. And they've been clear through their cases and enforcement actions that they expect employers to take steps to proactively identify problem areas, cultural trends that may be going on in the workplace in order to prevent sexual harassment, as well as, and this is in addition to, responding to the individual complaints that you may receive. The employees that come to your office and report individual acts of discrimination or sexual harassment or concerning behavior. It's not just enough to address those individual complaints. The EEOC wants to see something broader than just in responding to individual complaints. Retaliation, we want to mention that very clearly. Encompassed in all of these anti-discrimination laws is also a prohibition against retaliation. So we need to be clear with our managers, supervisors, and other employees that anybody who retaliates against anybody who reports sexual harassment, participates in an investigation, or otherwise cooperates in addressing sexual harassment may not be retaliated against. And that in and of itself is a separate area that exposes the employee and the employer to liability. There's New York State law in this area as well. This is coming from the New York State Human Rights Law, which similarly identifies sexual harassment as a form of sex or gender discrimination. The state law in this area says that the conduct to be sexual harassment must be severe or pervasive, so that one joke may not necessarily be sexual harassment under the law. However, I say that with a huge, asterisk footnote to it, big however. The state division and the courts are going to be looking at the totality of the circumstances. So that's not a bright line rule. One joke or offensive remark may not be sexual harassment in one case, but it could very likely be in another depending on the facts, depending on the nature of the joke and the parties involved. I'll just mention, just very briefly, I'm not sure if anybody on this webinar right now has work sites in New York City, but if you do, you should be mindful that there is the New York City human rights law that is much more expansive, broad, and encompassing in this world of sexual harassment. So conduct that may not, be unlawful under federal or state law could very likely be unlawful under the city human rights law. So I just wanted to flag that for anybody who does work in the city. Over the summer, there were several amendments to the New York labor law and human rights law in this area of sexual harassment, such that by October 9th, which is next week, all employers have to have and distribute a sexual harassment policy. And in that policy, there has to be a definition of sexual harassment that is consistent with the law, state law, examples of conduct that would amount to sexual harassment, a complaint form, an articulation of an investigation process that is consistent with due process, and provide information for employees on the remedies available to them, not just remedies that are available to them in the workplace, but also through administrative agencies and through the courts. Finally, training. This is another requirement now that is coming from the state. By October of 2019, so we're now talking about next year, all employers have to conduct annual training in the area of sexual harassment. And the changes to the state law have set out specific requirements that have to be in that training. And I just wanted to say a quick note now on training. Generally, what we recommend is that training not occur after an incident has occurred. The best type of training is that which is proactive, that which is a part of your regular culture, that employees are required to attend, not necessarily when things are bad, but when things are good, and that it's not the concepts of sexual harassment, workplace misconduct are not just discussed once a year in passing, but are part of a continual conversation about workplace expectations, professionalism, that the employer is engaging in different ways with their employees. Training in different methods is an effective way of underlining the importance of these concepts, not just perhaps online training, but in-person training, small group trainings. These are all different techniques that can be employed together to sort of hammer home the importance of these concepts. We also find that when senior leadership attends these trainings, when your employees, people who are working on the floor, see the leadership, see the senior people in the company present at these trainings, that sends a very effective, very clear message to the whole company that these concepts are important and that these are values that the company takes seriously. Generally, there are two types of sexual harassment, quid pro quo, which is another way of saying this for that type of harassment. An example of that would be, a supervisor telling his or her assistant that if she goes out to dinner with him or her, she'll get a raise. In other words, subjecting someone to conduct in exchange for a change in the term or condition of their employment. Hostile work environment is another type of sexual harassment, and to be honest, the type of sexual harassment we see most often. It is perhaps more difficult to identify, particularly if the workplace is one in which where certain types of behaviors have been tolerated historically for long periods of time. It may be difficult to identify an issue if, as Tyler was mentioning, there is a culture of saying, well, what's the big deal? This is just a joke, et cetera. These are some examples of hostile workplace sexual harassment. These examples are ones where alone or in combination, depending on the context, could create a hostile environment. You have this list in front of you, but something we would add to this is that sexual harassment can occur even if the employees or the individuals who are engaged in certain conduct are not in the workplace when it happens. So off-duty conduct can create a hostile work environment. And the key question in that analysis is, what is the nexus to the workplace? In other words, you have to examine when you are doing this investigation, when you are looking into a complaint received, how has this conduct that occurred off the work site affecting the workplace? How is it affecting the employees and their lives in the workplace? We see a lot of problematic situations arise when coworkers go to work drinks after work. Even though you're not at the job at the moment and you're off somewhere away from the work site, you never stop being employees. Your leadership position never goes away. You never stop being someone's supervisor, even though you're not in the office. Online harassment is another forum in which we're seeing increasing numbers of sexual harassment complaints. As you can imagine, social media, Facebook, Instagram are ripe for this sort of thing. When coworkers are messaging each other through these platforms. We've had many cases involving social media, and many cases have gone through the courts that look at online conduct. How many times someone likes an Instagram post can be meaningful to a sexual harassment investigation. What photos were liked versus what photos weren't liked. All of these specific facts are important to a sexual harassment investigation. It's part of a thorough investigation, and as we're going to get to in a couple of minutes, would be the types of questions that you would want to be asking as individuals in human resources or otherwise who would be participating in an investigation. Sexual harassment, of course, can occur between men and women, between persons of the same sex, regardless of individual sexual orientation. And we talk about sexual harassment or sex discrimination, but in this context, that also includes harassment based on sexual orientation, someone's gender identity, or the status of being transgender, or perceived gender identity. That's an important component of that. One's actual gender identity or perceived gender identity can all be factors in this.
Thanks, Kate. So these laws that Kate has mentioned generally protect employees, but they also protect unpaid or paid interns and even non-employees who work in the workplace, including independent contractors. And those employed by companies to provide services in the workplace. I know temp workers are very, very common in the manufacturing industry, and if you receive a complaint from a temp worker saying one of your employees has harassed me, you can't simply say, nope, not my responsibility, nothing I can do about that. You're different, go to your temporary work agency. No, it's your employee is the one who's engaging in the harassment. And it's your workplace. You have an obligation to do something about that behavior and investigate that behavior. Similarly, in bullet 2 here, as Kate mentioned, I mean, many employers, especially 10 or 15 years ago when social media was really just emerging on the scene, you had texting and all the other variety of communications that have dramatically changed our lives in the last 10 or 15 years. Employers would get reports from employees of bullying or harassing outside the workplace in these environments, and they would simply say, nope, not my responsibility. That's outside of the workplace. That's something different. I have no obligation to look into that complaint. And as Kate mentioned, the evaluation is, okay, there's this harassing behavior happening outside the workplace. Does that have an impact on the workplace? And very likely the answer is going to be yes. If somebody's harassing someone and they have to work side by side in the workplace or even see each other at the workplace, that's going to have a nexus to the workplace, and it's your obligation to investigate and do something about it. However, You certainly do not want to be conducting an investigation that includes friending workers on Facebook or improperly gaining access to Facebook walls or profiles, but you should not ignore posts or information that is brought to you by a complaining employee. Don't go MacGyver. You don't need to go very, very deep or engage in any sort of fraud to gain access to materials you shouldn't have access to, but don't ignore material that is brought to you. So the primary takeaway from this slide is just don't put your head in the sand and try to pass off responsibility on some other entity or someone else. If there's harassing conduct that's having an impact on your workplace, you have an obligation to do something about it. And we'll talk about what that something is when we talk about the investigation piece. All right, so now I understand that the definition of severe and pervasive and what's unlawful or lawful under the law is a complicated one to apply. So I think the most useful way to try to analyze it is to use hypotheticals from actual cases that have occurred here in New York. All right, so if you're still here and still paying attention, I want you to feel free to participate in these hypotheticals with your thoughts. And again, these examples come from real cases. So in this particular case, this manager is accused of slapping male employees on the butt on a regular basis as far as a good job, good work. And he also oversees a female employee who's the one who ultimately filed the lawsuit. And he also slapped her on the butt 3 times over the course of 2 years. In addition, this same manager, again, as we talked about before, where he's, again, in his mind, he's just keeping things light, and this is playful activity. Of course, it's not, and it looks terrible when it's actually put down on paper, which everyone needs to think about is what a lawsuit is going to look like, where this behavior that you're saying is just joking around is just playful. In this case, again, he mooned 4 male employees, and the plaintiff also saw this mooning once. Finally, the same manager referred to the plaintiff as hot lips and regularly told jokes of a sexual nature to male employees, which plaintiff overheard on occasion. So the question here is, and again, feel free to chat and participate, is whether this conduct is severe and pervasive enough to be a hostile work environment. And I will pretend that we've got an answer here, and the answer is likely yes. In this particular case, this case got past summary judgment, and before a trial was held, they settled with the employee, but the employer tried to file a motion saying, nope, this isn't severe and pervasive enough to constitute a hostile work environment, so this case should be dismissed. The court denied that motion. So this was considered to be enough for a hostile work environment. So that's example 1, hostile work environment under all the laws, under the Title VII, under the New York City law, and certainly under the New York State law as well, all considered to be a hostile work environment. And Kate will cover workplace environment number 2.
So in workplace number 2 here, we have a situation where over a 1-year period, the plaintiff witnessed 2 male coworkers watching pornography on a cell phone. Pictures of male and female sexual organs were drawn on the wall of the factory and painted over once reported. The manager is alleged to have attempted also to look down the plaintiff's shirt while working next to her. And I'll throw the question to the group in case anyone cares to weigh in, whether they think this scenario that I've just described here would result in a similar outcome in the courts as Tyler described in workplace number 1. If anybody has any thoughts on that, please type in if you care to. This fact pattern was pulled from a manufacturing setting, and this is a close call. This fact pattern, it was found there was not sufficient evidence here to support a finding of sexual harassment. However, we do want to underscore that this is a very close call, and further underscore that just because something may not rise to the level of sexual harassment, either we have somebody writing in that they definitely think this is severe, and I absolutely understand that reaction.
Interestingly, too, for this case was, I believe it was 2014, so it's interesting whether now in this environment this could constitute.
Exactly, and I think we are seeing a sea change in this moment. We're seeing the state with these amendments to the human rights law and the labor law, increasing its diligence in this area. So how the courts are going to be interpreting these statutes remains to be seen. But what I want to highlight for everyone is that just because something may not rise to the level of sexual harassment under the law, just because a court won't find it or the EEOC or state division doesn't make a finding of sexual harassment, that doesn't mean that it is not still a violation of your policy, right? You're going to have a policy that clearly prohibits this type of behavior, and you have the flexibility to address this behavior within your individual workplace. So the takeaway from this is not from workplace number 2 here, is not to say, oh, well, there was no finding, so this is not something we have to address on the factory floor. It is. This is an opportunity to act swiftly, to address this type of conduct. And frankly, other employees, even though they may not be involved in an investigation or assisting in the resolution of a complaint, are aware of conduct, and they see how employers react. And how the employers react is going to send a clear message to the other employees who had nothing to do with this, that either you do take this seriously and there will be consequences, or you don't.
Right. And that's how you change a culture.
Exactly.
All right. So now, so that's the general framework we're currently working under. I just want to quickly point out some special considerations for those of you who are working in unionized facilities, because again, things are a little different because you've got a third party who is also going to be included in this process. The first reminder is wine garden rights. If you're conducting a sexual harassment investigation and there is any possibility at all that an employee is being accused of wrongdoing, a unionized employee has the right to have a union representative present at that investigatory interview. And you, as the employer, have to provide the employee with that representative and a chance to consult with the representative before the meeting, or you have to cancel the meeting. If this is a situation where the allegations are of a particularly sensitive sexual nature, I would reach out to legal counsel on this, because there are ways to ensure the confidentiality of that union representative that he does not then disclose further outside of that room. So if it's a very, very sensitive nature, reach out to legal counsel on that. Also, similarly, if the union representative might be the individual, it might be a witness to some kind of improper conduct, or might be the accuser, this is a situation where you can request and require a different representative to be in the room with the employee. That employee doesn't have the right to be in the room. Again, non-union employers here listening, an employee has no right to legal or any other form of representation for these disciplinary meetings, and you can reject any request to have a representative present for non-union employers. The second consideration for unionized employers, and one that really all employers should attempt to abide by in these situations, is ensuring that any discipline imposed is for just cause. The difference here, however, is that in a unionized context, you're likely going to have to prove the discipline issue was reasonable to an arbitrator if the union challenges the discipline. So these bulleted points just highlight what an arbitrator will consider in determining whether the discipline was warranted. First is notice. Was the employee on notice that you had a workplace harassment policy or improper conduct policy, and that there would be consequences for violating the rule? And second, for reasonableness, is the rule reasonably related to the safety of the workforce? I can't imagine an arbitrator ever finding that a sexual harassment policy is not reasonably related to the safe operation of the business. But for example, if you had a rule like no touching ever in the history of the workforce, that might be a rule that's overbroad, but again, very rare that reasonableness will come in. The most important bullet here is the investigation piece. An arbitrator is going to scrutinize your investigation. Did you talk to all the relevant witnesses? Did you collect the relevant documents? If you did do that and you came to a conclusion based upon that, it is very rare that an arbitrator is going to question that conclusion. What he or she will question is, was the investigation conducted in a reasonable manner? Did you talk to the reasonable people? He or she is not going to generally question your ultimate decision unless it's so far off base it doesn't have any reasonable basis, but the most scrutiny is going to be on your investigation, and that's where we're going to spend a large bulk of the remaining 20 minutes here. One last consideration for unionized employers, and this is one where I suggest you reach out to either Kate or I, is when you change your sexual harassment policies, you generally have to bargain with the union over any changes to the sexual harassment policies. So this is relevant to changes that are going to be required under the new New York State and, for some of you, New York City laws. The way that the law reads, the law on bargaining is you need to bargain over any change. Sorry, let me step back for a moment. There's an exception to bargaining that you do not need to bargain over any change that is specifically required by law. However, many aspects of these new laws, the New York State and city laws, such as what exactly due process means, what the examples of sexual harassment in the policy may be, these all have some sort of discretionary element to them, which makes them subject to bargaining. It's not specifically mandated or required by law because you have some leniency in how you adapt these policies, how you define due process. You have some leniency. So, unionized employers, on a practical level, how do you approach this? What do you do? What you do is you draft a policy that you envision meeting the minimum requirements. We are just completing a draft policy here at Bond that complies with the guidance that came out yesterday. You draft that policy, and the policy that we're creating meets those minimum level requirements. And you propose that policy to the union and say, this is compliant with the law, this meets the minimum level requirements, let's implement it. And then you ask if the union has any questions. You don't need to broadcast, hey union, you have a right to bargain over this policy. You attempt to implement it and tell them, okay, this meets the minimum requirements, any issues. If they have questions and come back to you with questions and want to bargain, technically, yes, you have to bargain over it. But you don't need to broadcast with bright lights that they have an obligation to bargain over that change. I understand that this area is a little bit complicated, so feel free to follow up with us after the presentations with any questions at all on this when you're implementing your new policy change in the unionized environment.
So the investigation, we're gonna walk through sort of the basic steps in an investigation and offer some recommendations for best practices in that process. So the beginning, right? A complaint is going to come to you, and it may come to you in different forms and in unexpected ways. There's, of course, the easy and clear way in which a complaint will come to you, whereby somebody fills out the complaint form that, as of next week, needs to exist in your sexual harassment policy. They may complete that form and submit it to Human Resources. The more common, perhaps, or unexpected, it depends on your workplace culture. I shouldn't say common in all settings, but in some workplaces, employers more frequently receive complaints when they don't expect it. When they're having a conversation, when a supervisor is having a conversation with an employee in the break room, or they've walked out to get a coffee. And while doing that, an employee says, you know what, I'm really having a problem with John. You know, last month, this is what happened to me. And that comes out in conversation. That is still a complaint. The employer now, if you're in a supervisory position, is now on notice. So in both those scenarios, the more formal and the informal verbal complaints, all of that needs to be recognized as a, quote, complaint that needs to be addressed and go through your process. The complaints you receive initially could be vague. Somebody could tell you or write to you saying that her supervisor is treating her poorly or unfairly. This, of course, is nonspecific, and what is unfair or poor can mean many different things. But this is an opportunity for you as an investigator, or even before that as a human resources representative, to dig deeper into that. It's important that we understand when somebody says they're not being treated well, we need to understand what they mean by that. And of course, our understanding is going to be limited by the employee's ability to articulate what their concerns are. But we need to do our due diligence to not just brush off comments like those, but to dig down as best we can to understand why the employee has said something like that.
And even in case example where if a supervisor is out for drinks with employees, which again we suggest that not occur, if something occurs or happens or a complaint is raised in that setting, that supervisor, that knowledge still is attributed. Just because he's a buddy out having drinks doesn't make him any less of a supervisor in that moment.
Exactly. So the planning phase, this is sort of a technique that you can use as an investigator to sort of get your head together before you start the investigation or before you have that first meeting or interview with the complainant. And in that sort of what we're calling the planning phase, what you should be doing or what you can do is create a roadmap for yourself. Identify the nature of the allegations. What was it that was reported to you? Who are the parties involved? Are there any potential witnesses that you can identify at this very early stage of things? Where did the conduct occur? And what policies are implicated? So in other words, is the conduct that is reported to you covered by your sexual harassment policy? Are there other workplace conduct or expectations for employee behavior or ethics provisions in your policies that could also be implicated by the nature of the reported conduct? You want to just note that at these early stages because as the investigation progresses, you may find the conduct is more appropriately addressed under a different provision. Maybe it's not quite the sexual harassment, but it's still actionable conduct under another section of your employee handbook. Assess special considerations. So what we mean by that is it necessary to contact law enforcement? Doing so is not going to be necessary in most of your cases, but if there is a real concern about the health and safety of your employees or other members of your community, that might be something you need to do. Are there safety concerns? Does the accused person need to be placed on an interim suspension if there is a real concern about safety? Or is the alleged conduct of the sort where you think it is appropriate to put somebody on an interim suspension, or in other words, ask that person to work from home for a couple of days with pay, while you sort of get a handle on what the situation is. That's not going to need to happen in every circumstance, but depending on the facts and the parties, it may be appropriate. When you're doing that sort of thing, we do recommend you reach out to counsel because the implications of that, the union implications, can be complicated, and it's worth it to involve counsel in the early stages. Who's going to do the investigation? Human Resources is going to probably handle the bulk of your investigations, though outside investigators, legal counsel, may need to get involved with the more complicated cases. Outside investigators are often used, and we've functioned in this role before, are used when it's necessary to not only for more complicated cases, but when there is the concern about bias or perceived bias within the organization. It's sometimes helpful to have an outside investigator come in who's not seen to be aligned with any one party. In all circumstances, investigations, and you want to be mindful of this at the outset, should be fair, thorough, and prompt. Defining at the beginning sort of the scope of your investigation is important. By scope of the investigation, you want to try to articulate, what am I investigating? What are the allegations here? Your investigation is going to be sort of narrowly focused on what was alleged to have happened, not the entire background relationship of everybody the accused has ever worked with. However, and underscore however, as your investigation progresses, you may find it necessary to explore other avenues of investigation that were not necessarily on your radar when you started. So you're going to define an initial scope, but be flexible as you go through the process. As you're collecting documents, as you're talking to witnesses, these other avenues of inquiry will reveal themselves to you. Consider your interview order. In most cases, it's going to make sense to start with the complainant so that you understand to the best possible degree what the allegations are. It's not required to start with the complainant, but we do, find that that's a reasonable and logical place to start. Begin with open-ended questions and let the complainant and any witness or accused that you were talking to tell you what happened from their perspective without being interrupted with questions. Let them speak. And when they're done talking, that's your opportunity to ask your follow-up questions, to get clarity on things you didn't understand. I find that if you don't let the individual you're speaking with sort of talk for as long as they want to talk to you at the outset, and you interrupt them with questions, they lose their train of thought. And you've now lost an opportunity to fully understand what they were saying because they've forgotten, the idea they had in their head. You want to make sure in these conversations that you get the who, what, when, where questions out. If you need to take a break, to say to the complainant or any other party, you know what, I need to step out for 5 minutes. I want to sort of digest what you told me and see if I have any follow-up questions. Take those 5 minutes to gather your head because you don't want to have to call people back into your office on multiple occasions if you don't have to. Best practice is to have two investigators, two people in the room, one person asking questions, the other person taking notes. It's very difficult, to do both at the same time. We just have a couple of bullets here on sort of techniques as investigators, things to be mindful of. It's always helpful to, before going into any investigation, be aware of your own sort of biases that you may be bringing to a situation and leave those at the door. You are a neutral investigator, so be aware of any sort of facial expressions or body language that you may be projecting, and try not to. Use an even tone. These are difficult things, of course. We're all human, but the more sort of self-awareness we have in this process, the better. We're not there to judge. We're there to gather facts.
Yeah, one rolled eye can shut down an entire interview. If somebody feels like you're not taking it seriously enough, somebody will just shut down entirely if they get one roll of the eye or one facial expression they don't like. So be careful.
Right. And it's also not the time to make any comments on the appropriateness of conduct or the validity of a complaint. You're there. Your role at this stage of the game is to learn about the problem, and make sure you stress to everybody involved you appreciate their cooperation and their willingness to come forward. And it's very important that they do feel comfortable talking to you, and that no decision is going to be made until all the facts are gathered. So this is not the time to counsel employees on the appropriateness or inappropriateness of conduct. That opportunity, of course, is going to come up later. Consider interim measures. Depending on your workplace structure, interim measures could be temporarily reassigning supervisors to different employees if a supervisor is alleged of misconduct, or moving certain individuals to a different schedule while the investigation is ongoing. Requesting documents is also very important. Interviewing the accused is similar. It's going to go similar to your interview with the complainant. You want to reiterate your neutral role. and inform the person that an allegation has been made, the nature of the investigation that is ensuing, and give that person the opportunity to tell you his or her perspective on what may or may not have happened. Asking that person, as you did the complainant, for relevant documents is essential. Ask that person, is there anybody else we should talk to who you think could help us understand what happened? Both parties should be asked that question. The order of interview of witnesses can vary, but again, you're asking the same types of questions. You want to, in the course of this interview, determine whether any of the witnesses come with any kind of bias and take that into consideration as you're weighing sort of the credibility and weight of what any witness is talking to you about. Retaliation should be, your prohibition against retaliation should be discussed with all of the parties, including the witnesses.
And now for the conclusion of the investigation. You've done everything that Kate has discussed. You need to decide what the final report is going to look like. In very, very rare circumstances, an oral report might be okay, but typically you're going to want some final written document summarizing the report and conclusions. And you have to understand that this report is going to be front and center in any litigation. Any question of the conduct or the decision that you made is going to be evaluated. That's going to be the key piece of evidence for your conclusion. So you want to document what happened in the investigation, how you got there, and how you reached your conclusion. Also, as soon as you finish this investigation, the results should be communicated to both the accuser and the alleged harasser. This does not mean that you need to communicate every single detail of what was found, but you need to communicate the results and carefully decide in each case how much you want to disclose. And for the alleged harasser, if they do remain employed, this should come with a reminder that there can be no retaliation against this employee that complained. It is rare that parties are going to receive a copy of a final report in these scenarios, but in a unionized setting, a union may ultimately be entitled to this if they would like to grieve the discipline. So that's another consideration, that a union is likely going to have access to this document if they want it. And just some quick recommendations on the conclusion for next steps is, as Kate mentioned, you want to be proactive, but after an investigation is finished, this can potentially be a situation where you can start a shift in the thinking of the workplace and the culture. If harassing conduct did occur, explaining that an individual was terminated for certain conduct can send a message in certain circumstances to employees that this sort of behavior that's been going on for 20 years is no longer going to be accepted, and that things are changing in the workplace. So there also can be a valuable deterrent factor at the conclusion of the investigation. If conduct occurred that was not inappropriate but that does not rise to the level of discipline and suspension, this is again a time where you can take a chance to train employees, even if it's in a small group setting, just as a reminder of what appropriate conduct is. You don't need to pinpoint who was involved in the behavior, who wasn't. You can just say this is just a reminder of appropriate conduct, and there's going to be consequences if anything like this happens again in the workplace. So with that, we have a very quick hypothetical. I don't know if we're going to have time to get through it, but if you want to stay on with us for a minute or two, feel free to stay on. If you have to go, that's fine as well. And again, feel free to reach out to either of us with any questions. Okay.
So this third example, hypothetical here, is an interesting one where we have a supervisor who is making complimentary statements to a female employee. He tells her that he admires her necklace and hair. He places his hand on her shoulder or forearm during meetings to emphasize a point when they sit next to each other. He says that she has a nice smile and frequently likes Facebook photographs that she has posted and posts heart emojis under one of her photos. If anybody cares to write in and share their thoughts on what they think about this, please do. But I'll add is that this may very likely not, whether or not this rises to the level of actionable sexual harassment under the law is questionable. Certainly under the state and federal standard. Under the city standard, I would be much more concerned. But that's sort of beside the point. This is behavior that is not ideal. some would argue highly unprofessional, and is still a counseling opportunity for you. This may not have to result in conduct charges against the supervisor, but it may very well be a reason for a conversation with the supervisor about boundaries, about what is and isn't appropriate, for your workplace. You can leave it at that. Not every scenario needs to result in discipline. And I'm not saying that this scenario shouldn't result in discipline. That is somewhat discretionary and depending on your policy. But there is flexibility that you have to address conduct like this early so that it doesn't escalate to something more.
And these are a couple of quick questions relating to the hypothetical. The first one is, the supervisor asked for Weingarten representation prior to being interviewed. Should he receive it? So the big qualifier and the big decision, the big answer here is that a supervisor has no Weingarten rights. They are not a unionized employee. They have no rights to Weingarten representation. That is only for unionized employees. So a supervisor here does not have any right to any representative. The second question, the conduct rising to the level of sexual harassment, Kate discussed that. Likely under the New York City law, probably actionable sexual harassment under the New York City law. Under the federal and state law, probably not. But again, the legality of it all is not the important part here. This needs to be some kind of counseling.
Right. And would it matter, that the employee sent the supervisor a message stating thank you for the like? Does that make this now something that was unwanted or wanted? That's an important question to the sexual harassment analysis, so I think the fact that an employee sent this message alone is not necessarily dispositive. I mean, there are a lot of other factors that would need to be looked at to assess that question of unwanted. Who else would you like to interview in this scenario? I think interviewing other people who are present at meetings where the two of these people are present to see how the supervisor is placing his hand on the employee would be helpful. There are probably other people that would be useful to this investigation as well.
Okay. All right. So we have this is the question session. So the question one is, isn't there an NLRB ruling that all employees can ask for representation? So back in 2001 or so, there was a case that said, yes, even in the non-union environment, you can have the right to union representation. However, that case got overturned about 6 years later, and the law has been consistent for the last 10 or 15 years, and it was actually just reaffirmed in a decision by the NLRB General Counsel saying that in the non-union environment, non-union employees do not have Weingarten rights to union representation. They can certainly ask for it, is the question, but that doesn't mean you have any obligation to provide it to them, and you don't want to set a practice of providing that sort of representation, I would think. Also here, we'll put our contact information up on the end of the slide.
Okay, unless there are any other questions, we'll just say thank you very much for joining us this morning. And if anything comes up, anything we can help you with, please don't hesitate to reach out.
Right, especially with these policy changes that are going to be required in the immediate future here. Please reach out. Thank you.